Hello, and welcome to today's Center for Audit Quality webcast entitled Auditor's Responsibility When Illegal Acts Are Suspected, How 10A Really Works in Practice. I'm Cindy Fernelli, Executive Director of the Center for Audit Quality, and I'll be your moderator for today's program. Before I introduce our featured speakers and jump into today's program, there are a couple of housekeeping matters that I need to cover with you. First, we'll be taking your questions during today's program. To submit your question, you'll see a question field in the lower portion of your screen. Just type in your question and click on the link labeled Send Question. We will then collect your questions throughout the webcast and have the panelists address them during the question and answer period. Second, for those of you who have signed up to receive CPE credit for this program, the CPE standards require us to take attendance during the webcast to verify your participation. Once, during today's program, you will be given and asked to write down a unique CPE program code, beginning with the word ALL. Once I give you this code during the last half hour of the program, you should write it down and keep it with today's program materials. This is only for viewers who have signed up to receive CPE credit for today's program. Additionally, for those of you claiming CPE credit in California, it gets a bit more complicated. Again, this only applies to California CPAs seeking credit. The California CPE rules require you to have 3 additional interactions with us during today's program. These additional interactions will take the form of a pop-up window that will appear in the PowerPoint slide window of your screen. When you see this pop up, you should immediately click on it to register your interaction with us. So California CPAs need to write down the 1 CPE program code that I'll give out during the program, plus click on the 3 additional pop-ups that will appear during today's webcast. Then, later in the program, I'll tell everyone how to use this information to document your CPE credit. Now on to today's program. Once a public company auditor determines that an illegal act has occurred, Section 10A of the Securities and Exchange Act of 1934 contemplates a series of steps which serve to advise the appropriate parties and protect investors. Our 3 distinguished guests today will provide their unique perspectives based on their experience and knowledge when illegal acts at a public company have been suspected. Their viewpoints will represent the 3 different roles in which Section 10A investigation would be conducted and are as follows: the role of the forensic specialist of the audit firm, the role of the audit committee's forensic accountant, and the role of counsel to an audit committee. Today's program is designed to specifically address Section 10A of the Securities and Exchange Act of 1934, circumstances requiring a 10A investigation, the structure, independence, and process of an investigation, what is meant by timely and appropriate remedial actions, and the risks to the auditor from the SEC. We've got a great deal of material to cover today, and to help us gain a better understanding of the topic, we have assembled an impressive panel of experts. So let me take a moment to introduce each one of them to you. First of all, I'd like to introduce Dr. Tim Headley. Tim is a partner in KPMG's forensic practice, where he serves as National Forensic Services Lead and as Global Coordinator for the firm's Fraud Risk Management Initiative. He provides clients with a wide range of forensic services by assisting with the prevention, detection, and response to fraud and misconduct. Tim has also participated on a task force that wrote the AICPA Special Report on Forensic Procedures and Specialists, Useful Tools and Techniques. Tim will provide you with his perspectives in the role of the forensic specialist of the audit firm on the audit during our program today. Tim, we're pleased to have you join us today.
Thank you. It's great to be here.
Next, we have Steve Skalick. Steve is an advisory services partner and the global leader of the corporate investigations practice for PricewaterhouseCoopers. Steve has conducted significant investigations in the financial services industry and brings over 25 years of public accounting experience to his clients. He has testified in federal and state court at both jury and non-jury trials and has authored the text, A Guide to Forensic Accounting Investigation. On today's program, Steve will provide you with the perspectives of the Audit Committee's forensic accountant. Steve, we're glad to have you with us, and welcome.
Thank you. It's great to be here.
And joining us today also is Michael Young. Michael is a litigation partner with Wilkie Farr & Gallagher, whose practice concentrates on securities and financial reporting with a particular emphasis in accounting irregularities. His practice involves the representation of companies, audit committees, officers and directors, accounting firms, and outside professionals in securities class actions, SEC proceedings, and special investigations. Mike is also author of the text, Accounting Irregularities and Financial Fraud. As you can see, with this type of background, Mike will be providing you with his perspectives as counsel to the Audit Committee on today's program. Mike, it's great to have you with us as well.
Well, thank you, Cindy.
So we have a lot to cover today, so we'll begin by turning to Mike. And Mike, why don't you start by telling us what Section 10A is all about, and let's pick up on slide number 4 for those of you following along at home.
Well, Section 10A. Section 10A is part of the federal securities laws. It's directed to the auditor, what the auditor is supposed to do in connection with the audit of the financial statements of public companies. And at the crux of Section 10A is what is an auditor supposed to do when it finds potential evidence of an illegal act. Let's say you're auditing the financial statements and you see evidence of illegality or possible evidence of illegality. What do? Do you resign? Do you put out a press release? Do you call the police? And at the crux of Section 10A, now don't get me wrong, keep in mind this was written by lawyers, so there's a lot of gobbledygook and redundancy in there. But at the crux of it, 10A tells an auditor that if you find evidence of a likely illegal act, you really need to do 3 things. That's what it really boils down to, 3 things. First, evaluate the impact of that possible illegal act on the financial statements. Is it material? Is it not material? Second, see to it that the audit committee is adequately informed. And then third, evaluate whether the audit committee is taking timely and appropriate remedial actions. That's the key phrase, timely and appropriate remedial actions. Now, a typical auditor may wonder to himself, what's that mean? Well, I can tell you. The statute doesn't say. It leaves it completely to the discretion and judgment of the auditor, but that doesn't mean the auditor will not be second-guessed, because the SEC will have in its own mind what constitutes timely and appropriate remedial actions, and sometimes the SEC Enforcement Division will aggressively second-guess the auditor's judgments and come to a view whether the SEC thinks the auditor has done the right thing. So it is an area that is fraught with peril, and where the auditor really wants to think hard and see to it that the auditor approaches it in a way that he conforms to expectations, sees to it that the illegal act is dealt with appropriately, and that he's not going to get second-guessed by the SEC. One additional point in Section 10A. If the auditor should come to the view that the audit committee is not taking this thing called timely and appropriate remedial actions, then the statute calls for the auditor ultimately to go to the SEC itself. That is on a hair trigger. Section 10A gives the auditor 24 hours to do so.
Mike, I think picking up on some of your points, the difficulties of interpreting Section 10A don't just extend to the remediation area. Even the basic question of what is an illegal act is very broad within the Act. And it's, I think the language of the Act is any act or omission that violates any law or regulation having the force of law. So this is an incredibly broad purview that the auditor has to be thinking about. And what that means is that the circumstances requiring a 10A investigation can come from a whole different, from many different aspects of a business's operations. You can have, of course, violations of the securities laws, but also we're talking about things like anti-money laundering, violations of the Patriot Act. We're talking about OFAC violations might cause an investigation. Any foreign law for multinational corporations can be a source of a problem. Labor, OSHA, ERISA, antitrust, European competition rules, for example, or environmental laws. All of these different areas are areas that can give rise to a concern on the part of the auditors. The other thing is that the standard requires the audit thought process to be one where first you think about whether the act might be illegal, and after that, the second consideration is how it might affect the financial statements. So you really have a two-step thought process there. And finally, another very broad aspect of 10A is the catch-all concern that auditors always have when they feel an illegal act has been committed, which is how that affects the credibility of management on whom they rely for representations. And this issue is really a catch-all issue, and I think puts a lot of pressure on the audit thought process when illegal acts are suspected.
Steve, let me build on that, because you just made a very, very important point. First of all, your one point is the breadth of the definition of illegal act. I mean, the way it's defined, a parking ticket could, in a sense, almost be an illegal act as defined by Section 10A. Now, what does an auditor do if it finds a parking violation? Well, suddenly report it to the SEC within 24 hours? No, because it's not anything that possibly violates the law that needs to trigger a big investigation. And at the crux of it is, are you seeing evidence of illegality that calls into question management integrity? Are you seeing evidence of illegality where it looks like people at the company, and of course the risk increases the higher you go as to auditor reaction, are you seeing evidence of a wrongful intent, of somebody deliberately trying to falsify financial information or deliberately trying to evade the law? When you're at that level, where, for example, let's take the extreme case to make it concrete, Cindy, let's say you've got evidence that the CEO has cooked the books. Okay, well, then you're really in 10A land, and then you might have to call for an investigation. But it's not every single potentially illegal act that requires that kind of vigorous response.
I can give you some ideas or examples of things that may be indicia of a problem that require an audit response. And that audit response may or may not be 10A, things like unauthorized transactions, inappropriately recorded transactions, investigations by government authorities, enforcement actions, fines paid that aren't well understood, large payments for unspecified activities, particularly when they're paid to third parties, usually large cash transactions, cashier's checks made out to bearer, failure to pay taxes, or a whole plethora of things that you may not have. It may not say this is an illegal act, but there's certainly indicia there that an audit response is required from the auditor.
See, Tim, and I would think anybody listening to this discussion has got to be saying to him or herself, this is completely unhelpful, because you're describing it like fog. I mean, okay, I know I don't have to call for an investigation for a parking ticket, but gee whiz, what else can you exclude? And the thing is, that really puts or points to a significant aspect of 10A. When do you need to call for a big investigation? When do you be concerned? And it's really a matter of auditor judgment, which will be second-guessed.
Well, the auditor judgment, when they suspect indicia, they should take certain steps, understand whether you got some smoke, is there some fire here, do I need to move this thing up the ladder? Each one of these is going to be different, but they all require an audit response and a determination at some point that this is significant enough, there's enough evidence or enough indicia here of a very serious problem and a potential legal act. It's never up to the auditor to determine whether the law has been broken. That, of course, is up to a court of law when there's a fraud has taken place. But at a certain point, we have to say there's enough here for us to have to react to it and do something.
Well,
go ahead.
You mentioned a court of law making a determination. Does litigation play any factor in this? How does the interplay with illegal acts and an investigation interplay with litigation?
Well, I think there's a pretty direct interplay with litigation. First off, obviously, any litigation could contain allegations that an illegal act has been committed, and the auditor needs to be aware that this could be a source of triggering an investigation. The second interplay of litigation is more in the conduct of the investigation, and we're going to talk about that as we go through today's session, but obviously there's many practical aspects of the manner in which the investigation gets conducted that have a pretty significant interplay with any litigation that's been brought against the company at the same time. And it's often the case that there are class action lawsuits brought against a company that's announced the fact that it's undergoing an investigation into some form of illegal act. So I think there are two interplays with litigation that are common. One as a source of the allegation, no different, as it were, than a whistleblower or a government agency coming forward with a problem, and its impact on the practicalities of conducting an investigation. And Mike will talk more about that later when we get to the privilege issues.
One interesting point, I think, is that it's when we have to have a reaction, we become aware of the potential legal act. Oftentimes, in practicality, I don't learn about most of these when litigation's already taken place. Litigation usually follows the disclosure of a potential legal act, but every once in a while there will be litigation that will lead to it and require us to get involved. But most times it works the other way around. But litigation is a very important consideration.
Well, so we suspect there's been an illegal act. What do we do? How do we trigger this? When do we trigger the actual investigation? What are our next steps?
Well, let's suppose that the evidence of an illegal act is a whistleblower has come forward, or here's a real-life example. I got a call on a Friday afternoon. These things always come up on a Friday afternoon. I got a call on a Friday afternoon. I walked into a company's offices on Saturday morning, and I saw the CFO sitting at a conference room table sobbing. And I said to my partner, this is not a good sign. And so the first thing you need to do when you have, whether it's a sobbing CFO or a whistleblower or an anonymous letter or just something suspicious you see during the course of an audit that you think needs to be looked into, get to the bottom of it as fast as you can. What we call sort of a preliminary investigation. If you've got a whistleblower, you listen to what the whistleblower says, you ask about the documentation, you immediately talk to other people, and you get a sense, is there something here, or am I dealing with a crackpot? If there appears to be something there, and let's go to my sobbing CFO example where he says, I did it, I've been cooking the books, and I can't live with myself anymore. Well, then, at a fairly crisp pace, you need to take the first step of corrective action. And that will, in this hypothetical, involve alerting the public that they should not be relying on the financial statements. That may mean that the auditor goes to the audit committee, and if the audit committee hasn't thought of it first, raises the issue of whether there should be a press release.
Tim, he just mentioned the audit aspect of it. What does GAS require? What are the requirements from the auditor's perspective?
Well, it depends on how we look at this, because some of what we're talking about is sort of before this has hit the front line, so to speak. And I think an important consideration for auditors is that everybody in the audit team from the grassroots level up has to understand they have an affirmative obligation to report to the manager of the audit, to the partner of the audit, that they suspect there may be a problem. So that's one of the ways it will get escalated. But as soon as we have something that our GAS requirements are, consider the nature of the investigative team that may be hired to do it, consider the planned scope of work, consider the nature of the act, who involved, accounts affected, documents to be reviewed, potential scope limitations, which I think we're going to talk about later on. But critically important is that the audit team has to think about, are there additional audit procedures and other additional audit response that I should invoke at this point? Should I be thinking about increasing the scope of my own audit? Do I need to having more my own internal SAS 99 interviews? Do I need to think about more advanced testing of manual journal entries? So very specific things you have to do as an auditor when you become aware of these kinds of things and trying to understand what the response is going to be.
And Tim, I take it as a result of these considerations, you're going to reach a conclusion as the auditor whether you're going to call this to the attention of management so that management can take the appropriate steps and if management doesn't take the appropriate steps, you may have to go to the board of directors in the form of the audit committee and say, look, there's really something here that we find concerning. We think it may be an illegal act, and require them to take some action.
Absolutely. Companies have investigations all the time. And we go through this process and we look at all the things that are going on in an organization when you do the reviews of the compliance logs, what have you. But not all of them we say, hey, this really needs to rise to that kind of level. We went through this process and we said, if things are sufficient, it's probably fairly inconsequential. But you know what? We're going to continue, even in maybe not a 10A situation, but still shadow what they're doing to make sure at some point evidence doesn't come up that says that this must be maybe a much more serious issue or affect or imply that senior management or someone in a financial reporting position was involved in this. So even small things, we like to keep an eye on them, sort of see how they grow on the vine and what we need to do later on with it. So we don't just pass on all. We actually try to look at many, many things and decide later on how important they might be.
I think that's part of the judgment process.
Yeah.
Exactly. So if you're involved from the very beginning and monitoring it from the very beginning, that helps you make these
This
judgments.
is definitely an art, I would think. If you agree
The
with me.
the whole thing is laden with judgment.
Yes,
The
laden
whole
with
thing
judgment.
is laden with judgment.
Well, so let's talk then about a structure of an investigation. How do they work? How do they get set up? Where are the various pieces? Who are the various parties? Let's talk about that.
Vitally important, Cindy, vitally important, because if the investigation is not properly structured, then the likelihood of a successful outcome, an outcome that really digs out what has happened, goes down exponentially. The critical thing here, and this is something that auditors will naturally appreciate, the critical thing here is that if there is potential illegality with regard to misrepresentations in the financial statements, the auditor has to wonder, was senior management behind it? Because people, mid-level people don't normally cook the books on their own. Often it's because of a bad tone at the top. We all know that phrase. It may be because of pressure from the CEO or the CFO trying to meet quarterly analyst expectations or worried about ratios and loan covenants. Senior management cannot investigate itself. It's against human nature to want to investigate oneself, and that means the investigation has to be independent. So if there's going to be an investigation of financial impropriety, that normally means it's got to be overseen by the audit committee. The audit committee has to take responsibility for it, they have to take ownership for it, and they have to directly see to it that it's properly done. With regard to this, an aspect of Sarbanes-Oxley kicks in, which provides the audit committee with funding. The audit committee doesn't have to go to anybody else. It gets its own funding. It can hire its own professionals. And typically, those professionals will include forensics accountants to help the audit committee get to the bottom of it. And also, of course, there will be a law firm. And so normally the structure is the audit committee, as the independent committee of the board with responsibility for oversight of financial reporting, will be the overseer of the investigation. It will hire an independent law firm that has not had a lot of, or any perhaps, reporting to management in the past, and that law firm will hire forensic accountants, like Steve.
Right.
What do you do, Steve? What's your role?
Well, we work with the attorneys to first investigate the facts of the allegations and determine whether there's any merit to the concern that an illegal act may have occurred. And that's the primary responsibility of the investigation team. It's their responsibility to set the scope of the investigation and structure the investigation in a way that will, as speedily as possible, uncover the facts and inform the board as to what steps they may have to take. Now, there's a lot of different aspects to that process, and depending upon the circumstances, the structure of the forensic team may vary based on the size of the company, the issue involved, the number of countries or locations that you have to deal with. And we generally find that it's very helpful to have both accountants as well as technology experts involved in the investigation, because it's so important today that any investigation deal effectively with the technological world. We also find it's very important to deal with the cultural considerations that you may be confronted with in an investigation. And they really revolve around what business or industry the company is in. You may need to be familiar with substantial amounts of jargon. There may be specialized operating practices. There may be special rules or regulations. It's very helpful to have people with a background in those areas. And it's also important to deal with the cultural issues. If you're going to have to conduct the investigation in foreign locations, you'll have to deal with the language barrier. You may have to deal with different attitudes towards privacy and sharing information and that sort of thing. So these are important, I'll call them substructural elements of the team. You know, it's how you structure the forensic accounting team to work effectively with counsel, but you know, I would echo Mike's comments on the overall independence of the team is probably of critical importance. And one way I always like to think about that is if you imagine that the best case is true, there is no illegal act, nobody's done anything wrong, all of the people who are accused are exonerated by the findings in the investigation. You know, sometimes that can be very difficult to accept. And the thing that makes it acceptable is the independence of the investigation team and the thoroughness and thoughtfulness of their scope. And it's really the only thing that, you know, substantiates an exonerating finding. And since obviously, you know, anybody who's in one of these situations hopes for the best, you really need to put the right structure in place or you won't get to the outcome that you want.
And Tim, what's the role of the audit firm? What's the oversight function of the audit firm in this process?
The oversight function of the audit firm or the oversight function of a forensic professional in the audit?
Well, more precisely that.
This is interesting. If you think about it, you've got a potential issue that's taking place. They've hired Mike, they've hired Steve, they're professionals, they're coming in. The audit team has certain obligations under 10A to understand that investigation, its efficiency. Most auditors, or many auditors, have never seen a fraud in their life, or they've seen one fraud in their life. They are not trained professional investigators. So they're not necessarily able to evaluate how appropriate the work that Mike is doing and that Steve is doing. So a lot of the larger firms will bring their forensic professionals. Steve and I do similar work, but they'll bring me in on the other side and say, we're going to need your help in understanding meeting our requirements under 10A, because you have experience in doing this. It works great for some of the larger firms. I know a lot of the firms, and some of them on the call here, don't have those skill sets in-house. But this is not necessarily problematic. This is a serious enough an issue, and I think you'll back me up on this, that they probably should reach outside. There are wonderful boutique forensic practices where they can bring specialists in to help augment their own on the team. They're certified fraud examiners, new credential out by the ACPA called the CFF. There are a lot of trained individuals who can come in and help smaller firms deal with this issue. But this issue is important enough to make sure you have the right skill sets on board to be able to assess what my colleagues are doing.
If I could jump in with a cautionary note on that. I think all of those are good suggestions, but I do believe that fundamentally, and perhaps I think this is true of all audit teams, perhaps it's a bit more true with audit teams that might be at smaller firms who maybe don't see this as frequently. But the fundamental thing is the auditors got to change their thought process. They've got to realize they're now in a situation where there's a high demand on their proactive participation and thinking through how they're going to audit in this situation. This is no longer show up at interim and do your control procedures, show up at year end and do the financial statements. This is now going to be a pretty side-by-side exercise to keep pace with what's going on.
The audit engagement partner can't subordinate his responsibilities to a forensic professional because it's still the engagement partner's audit. They have to be fully engaged in that process. So I agree with you.
Yeah, and Tim, let me build on another aspect of what you said, and it's so vitally important, and that is, you know, the auditor is sort of at risk here. And you guys are too polite to say it, so let me say it since I'm a lawyer. Sometimes the audit committee will get a law firm to investigate, and the lawyer won't do a very good job. Sometimes you wonder whether the investigation is more of a whitewash. And candidly, I've seen that. I've seen it, for example, when I've advised auditors. You get a law firm, and they're not doing a good job. And the problem with that is, if the investigation is not thorough, and then the auditor relies upon it in issuing an audit report, the SEC goes after the auditor. Now,
I think that's a really good point, and I just, the advice I always like to give people in this area is everybody's got to be in their role. And what that means for the auditor's got to remember they have to audit the investigation.
Yeah, that's a good point, Steve.
And they can't lose their skepticism over it, and they can't be intimidated by the fact that there's a lot of lawyers maybe involved in the situation. They have to stay enrolled.
Well, speaking of lawyers being involved, we have a question from one of our viewers who wants to know, should the auditor, given this conversation that we've just had about some of these risks and some of these roles, should the auditor have his or her own attorney?
I will tell you, in my experience, and of course I investigate for audit committees, I also advise auditors. The big firms typically, in my experience, virtually always have their own counsel involved. It may be from the Office of the General Counsel, from within the firm, because the big firms typically, these days especially, have lawyers in-house who are specialists in 10A investigations. Some of the smaller firms will go to outside law firms to advise them. A lot of this is knowing what the SEC will expect and making sure you do what the SEC will expect so you don't get in trouble later on. So there's a real role for lawyers.
We have a large OGC function, so we can support this AC. I wouldn't just do this. It wouldn't just me and the audit partner. We'd bring in other resources from our practice, our national office, and what have you. But again, the smaller firm, I think that's probably a legitimate consideration, whether or not they should retain an outside counsel to advise them in this space.
Advice about the process is always helpful. So any auditor who finds themselves in a situation where they believe they have to invoke 10A and see to it that management and the board are doing the right thing probably will benefit from the advice of counsel about the process and what the right thought process should be. And I would say for that reason, you probably can't go wrong consulting with counsel.
These are troubled waters.
Right. So, well, in particular, if you don't have a lot of experience, as you said, sometimes this will be the first time that you've seen one, and I think that's a testament to the profession. But when you do have one for the first time, especially if it's a matter of first impression, that probably is good counsel to seek counsel.
Also, to make sure that your audit partners and people doing the audits know how serious this is and be able to respond to it, make sure they get additional help. Even if your firm has the help, make sure you reach out to it.
We have another question which actually transitions us very well into our next topic, which is the attorney-client privilege. And the question is, how does the auditor get comfortable with the company's investigation when the investigation is conducted by special counsel who oftentimes insist on confidentiality and invoking the privilege?
That is an excellent question, and it introduces an area in an investigation where an auditor can unwittingly get itself into an extraordinary amount of trouble. The direct answer to that question is that the auditor has got to see what the auditor has got to see. The auditor is going to have responsibility for the thoroughness, scope, and adequacy of the investigation, and that means the auditor needs to understand it in as much detail as the auditor's judgment suggests. Will there be pushback? Yes. The audit committee will say, we're not going to give it to you because it's privileged. The auditor's reaction to that is, I'm sorry, we will not allow the assertion of privilege to stand in the way of us getting the information. That is important for two reasons. One is the auditor has got to see the investigation, the results, in part so it can evaluate the need for corrective disclosure, the need for remedial action, the need for employee discipline, the need for employee discharge. That's one reason. A second reason is the SEC's enforcement division, and I'll apologize because I find myself mentioning the SEC a lot, but let me tell you, in this context, they're all over you. The SEC's enforcement division has taken the position that it is a violation of professional responsibility for an auditor to allow a company or its audit committee to assert attorney-client privilege as justification for not providing the auditor with investigative results. And there was one unfortunate instance in which that happened, and the result was that the auditor was suspended from practicing before the SEC. Why? Because the auditor allowed the assertion of attorney-client privilege. So the answer is you got to blow through it. You got to get the information.
I think the one formula for thinking about the problem that may be helpful is the primary purpose of the investigation, of course, is to discover the facts. Discover what happened in the conduct of the business, whatever the business is. And the facts are probably not privileged. I'm not a lawyer, so I probably shouldn't be giving any advice about what is or isn't privileged, but my general understanding is the facts and circumstance of a prior act in the normal course of business, or even if it's an illegal act outside the course, not really a privileged thing. The auditor is entitled to know what their clients' employees have done on behalf of the corporation and evaluating the impact on the financial statements.
Yeah, the problem with that is certainly the lawyers will assert that it's privileged, and the facts are probably collected into some kind of investigative results or report, and the auditor will want to learn the facts as collected by the lawyer. So this ties back to the need for legal counsel. You've got the audit committee lawyer saying, I know the law, you, Mr. Auditor, don't, and I'm telling you it's privileged, and I'm telling you you're not entitled to it. And if you're a poor engagement partner going through it for the first time, how do you react to that?
On a practical note, before you reach what you're talking about is a scope limitation to the audit. Before you get there, a practical way to think about it is understand and make sure the audit committee understands up front that there are practical limitations in maintaining privilege. And to have these conversations about privilege before the investigation gets underway. Because then the last thing you want to do in any one of these things is try to do a post-mortem on the investigation. You're already done the path, they think they've got privilege, they're not going to give it up, and you're trying to figure out what happened. You want to avoid that. You can do it right up front. And it makes a big, big difference because you want to let them know up front. If you let the audit committee know that it could lead to a scope limitation.
There needs to be an investigation up front between the auditor and the audit committee covering the complete structure of the investigation. We want independence. We, as auditor, want to see what we need to see. We can't let you assert attorney-client privilege as justification for not giving us stuff.
Yeah.
That conversation should be up front. Otherwise, the auditor ends up behind the eight ball.
There are practical ways sometimes to deal with things that the auditor wants to deal with. There may be other ways to present the information, other ways to acquire the information. You give these conversations up front. I've never had one where I couldn't do what I had to do because of attorney-client privilege, because we were able to work it out up front and have the discussion, make sure that the audit committee understood it as well, what our limitations were.
And I'll tell you, when I'm audit committee counsel, I advise the audit committee, let's have an upfront conversation with the auditor. Vitally important to set expectations at the outset.
There are a lot of instances where that does not happen.
And everybody suffers from it.
Yeah.
I guess one of the things that people argue about over the privilege many times, Mike, is to your point, it goes to the accumulation of the information, is the interview process. And obviously, many counsel assert a privilege over their interview notes, certainly over interview memoranda that they may have prepared to summarize the information they've collected. And, this is obviously an integral part of any investigation because you are obtaining your evidence both from the documentary record, either physical or electronic, and your other source of information is, of course, conducting interviews. From a forensic perspective, the interviews are probably going to be conducted with an attorney from the investigating team, probably an accountant to assist, assuming the topic is appropriate. Obviously, people might differ as to exactly how to do it, with or without documents, more than once, try and see each person once, can take different approaches depending upon the circumstance. I like to interview only one person at a time. Sometimes, the client will say, well, here's my team, you can talk to us all at once. I don't really think that's appropriate. I don't think that leads to the best fact-gathering process, but I appreciate people can have different approaches on it. So, the interview process is pretty significant, and it does raise not only the privilege question, but I think it also raises the question of, what's the auditor's participation in that process? I don't know what your experience has been, Tim.
Whether or not to participate in the interviews. Well, sometimes that can be problematic, because if you are starting to participate in the interviews, you don't want to be seen as managing or guiding or directing the investigation itself. It's always a danger. So there may be some advantages of being in the interviews, but oftentimes there are ways to get what you need, to glean what you need from those interviews without having to attend. And usually you can do that with briefings from, understand the questions are going to be asked, who they're going to be asked to, perhaps see the interview notes, unless we're going to be discussing a privilege issue, or I get, and I've had some very successful instances where I've had wonderful debriefs from the attorneys who are conducting the interviews, who were able to add a lot more color into it from their examination of documentation, other interviews they conducted, other things they've learned. Sometimes there are ways around actually participating in person, but always be careful. You can't be in a position where you're perceived to be directing or guiding an investigation.
Let me stop you there, because we have that very question. Why is it the question is, can the auditor direct the investigation or conduct the 10A investigation? I'm hearing you say that's not to happen. Can you explain that?
I think in can an audit firm do the independent investigation for its audit client? According to Sarbanes-Oxley, I think that's going to depend on the nature of the investigation. If it's clearly an inconsequential investigation, I think they're allowed to under Sarbanes-Oxley. A lot of firms, though, take the approach that we will not do under any circumstances investigations for our own audit clients. But you could not do an investigation for on an audit client where you knew there was some sort of malfeasance on the part of the CEO of the organization that was clearly a 10A issue and was consequential. Most likely that would be an inappropriate activity.
I think the thought process behind that is that once the auditor invokes 10A, what they've done is they've put a duty on management and possibly the board. And it's up to management and the board to carry out the investigation. And I think it's appropriate for the auditor to assist by giving their point of view and advice to the investigators to help the investigation along. Now, obviously, the auditor has its role overseeing the investigation and using the investigation results as part of the audit evidence. But I think all of that suggests that direct auditor conduct of the investigation under 10A is a bit inconsistent with its underlying principle.
And here again, the auditor is placed in a real tough spot, because if the investigation is not adequate, the auditor will want to tell its audit client, you're not doing a good enough job. And in the extreme case, I mean, I've had situations more than once where, as counsel to the auditor, and Tim, this builds on your point about the forensic or the auditor not getting the results till the end. The auditor gets the results at the end. Say the company's been through a 6-month investigation that's cost $5 million, and the auditor looks at the results and says, I'm sorry, this investigation is not adequate. And in fact, your law firm and your forensic accountants have lost credibility with us as auditor. We don't trust them anymore, so sorry, but you need to fire your law firm, you need to fire your forensic accountants, hire a new law firm, hire new forensic accountants, and start over. That's the downside. So I quite agree that there is a danger and a downside to the auditor running the investigation, which it doesn't want to do, but it has to be able to trust the investigation. Yes. And it has to offer its input, as Steve said.
Yeah, that's why it's imperative that the audit team is in lockstep with the investigative team.
Absolutely.
Lockstep all the way down the line.
And if the auditor finds that it can't trust the investigation, that's something that the auditor wants to deal with. That's a real problem.
So how do forensics play in that? Can forensics help the auditor trust the investigation?
I think tremendously so. And, from a forensic perspective, this whole process of conducting the investigation and responding to the allegations and getting to the right results starts with the consideration of the scope of the investigation. And this has really got to be a consultative process between investigating counsel, their forensic accounting advisors, and their principal client, which is the audit committee. And they have to sit down and map out what is the allegations that are concerning and come up with a plan to investigate those allegations. A lot of people hear, 10A investigation, and they immediately have visions of the ocean being boiled, and, people running amok and so forth. And unfortunately, that's probably happened, and, some bad examples out there. But the key here is that there needs to be a good thought process around scope. And the thing that everybody has to keep in mind is the scope can always be increased. It's not necessary to have, the exact perfect fit scope right at the beginning of the investigation. You start with a sensible target and you investigate, and it's an iterative process. If your findings suggest the scope needs to be expanded, then you expand it. And my own practice, I like to check the scope of the investigation at the beginning, after we've had the internal conversation among the investigating team. I like to involve the auditors and meet with them, and it's a good opportunity for them to comment on the scope. I find audit input especially helpful on the context of people to be interviewed or considered, because the auditors know the organization. And I also find it very helpful in terms of some of the electronic investigation that's going to go on. The auditors know the company jargon, they know the buzzwords, and they can really contribute a lot to having a solid search term set. Again, one that is appropriately targeted, doesn't bring back too much or too little in terms of results. So I think this scope setting process is really very much at the core of the initial forensic step. The other thing in this day and age that is just an absolutely essential element of any forensic investigation is dealing with the electronic world. I mean, there's just so much out there, and everybody's got their favorite story of, emails pasted on the conference room wall and so forth. But, the fact of the matter is it's not a joke. It's an essential element of any investigation, and you need to figure out, which emails, which people, what locations. You need to be in close coordination with your client's IT person, because obviously you're going to have some pretty extraordinary access to their IT systems. You're going to have to focus on accounting systems. You may have to focus on business systems relating to sales processes that are rarely, if ever, touched in the course of the audit, and that may be awkward for the client people because they're not used to getting requests for information from those data sources. So it really means that your forensic technology professional is an essential element of any forensic exercise.
That's interesting, because whenever I hear there's going to be an attorney's brought in a forensic technology outfit to do the work, I have not heard of them, don't understand them. I'm going to ask to have a conversation up front to help assess their competency to do the work. Can they pull this off? Can they do the kind of quality job that needs to be done on my audit client? Or if they can't, this is going to be problematic for me. But I'll have my forensic technology people talk to them on the phone to understand the software they're going to use, the technology they're going to employ, the backgrounds, how many of these they've done. So I have a comfort level it's being done correctly.
And here, Tim, this brings to the fore again the excellence of your upfront point. Mm-hmm. This is something you want to do upfront, not 6 months after 6 months of searching through emails, and then they tell you what their process was, and they say, gee, sorry, that wasn't right.
Yeah.
Steve, to your point on scope, and I'll ask for forgiveness again for having to bring the SEC into it, but a thing for the auditor to keep in mind with regard to scope, and I agree completely that you start with a sensible scope and you can expand it. And for that matter, you can shrink it if you're going down a trail and it looks like a dead end. The SEC in these situations will almost always be doing its own investigation. If you're lucky, they'll allow the audit committee's investigation to go forward first, but they will second-guess the scope. And if they don't think the scope is right, then they will do their own investigation with their own scope. And if they think the scope should have been broader and the auditor has missed something because it went outside the audit committee scope, guess who takes it on the chin? Yes, the auditor. It's unfair, but it's the way it works.
Well, that can lead us into our next topic area, which is the report, because it seems to me that part of defining the scope and defining the roles and doing the work is the form of the report, that you're going to have some kind of report at the end to demonstrate that you've done this work, to summarize this work. And I'm guessing that there are probably pitfalls or things to watch out for with respect to the report, as there have been in all these other topics that we've just addressed.
It is one of the most awkward issues. And, of course, a careful listener will say, well, there's already a pretty long list of awkward issues. Let me say concretely what the typical issue is. Will there be a written report? Now, in these kinds of situations, if there's not litigation already, there's probably going to be litigation later on. And in a normal discussion, the company lawyers, those who will have to defend that litigation, may say to the auditor, well, to tell you the truth, I'm hoping there's no written report because it will be a roadmap. That's the common metaphor. A roadmap for the plaintiffs. And you know what? They're right. It will be a roadmap for the plaintiffs. If there was wrongdoing, it will set it forth. It will set it forth plainly and in detail. It will describe how the illegal acts were done. And the company lawyer will often tell the auditor, you know, if I write all this stuff down and then I give it to you, I've put all the wrongdoing together, I've lost the privilege, it will be subpoenaed by the plaintiffs in the litigation, and I'll lose the case. All of that is probably true. At the same time, the auditor needs to get what the auditor needs to get, and sometimes, you know, you hope it doesn't come to this stark inarticulation, but sometimes the company has to choose, does it want an audit report or does it want the attorney-client privilege? Does it want to keep a report to itself? Now, that's not to say that you always have to have a written report, although the SEC has taken the position it's a violation of professional standards not to get a written report in a particular enforcement proceeding. But these days, the way audit committees and auditors seem to be approaching it is, here again, you sort of do what your judgment requires. Now, the auditor has to get the information. That's not debatable. But sometimes you can get the information orally. Steve, what's your experience?
Well, as the forensic person, you know, I always try and keep in mind that our primary mission is to find and establish the factual information about the allegations being investigated. So from my perspective, you know, the thought process around should there be a written report or not revolves around how clear are the facts. You know, in a situation where it's pretty clear that there's been wrongdoing and what it is, and the evidence is, say, perhaps documentary in nature, emails or business records, you know, there may be less pressure on this question of writing a report because it's easy to communicate the facts using the documents that have been discovered. You know, in other situations, it may be either a much more complex fact pattern or it may be much more dependent upon what people have said, so that a lot of the evidence is in fact coming out of the interviews that have been conducted. In this situation, you know, a written report may be very useful to the forensic team and to the audit committee, as well as the auditors, in establishing exactly what the facts were, because it's based on recollections at a point in time, and they fade and change as time passes. So depending on the circumstances, I can see different judgments being reached about whether a written report is really needed.
You know, let me just, Steve, you reminded me of something, and that is an approach that at least one of the firms takes, and that is the auditor will say to the audit committee chair, look, there's going to be documentation of this investigation. Either you're going to write a report and give it to us, or we are going to listen to your investigators and we're going to write it ourselves. And if we write it ourselves, it's going to be in our work papers and we control how we articulate it. So if you want control over how this investigation gets articulated, maybe you want to do that.
Well, Tim, regardless of whether there's a written report or an oral report, how do you, as the forensic specialist for the audit firm, satisfy yourself that you have all the facts, that it's an accurate oral written report of what's transpired?
It's not easy, but again, it goes to the point we've been making all along, how involved you've been in the process, how many updates you've had from the attorneys, how many conversations you've had with the forensic accountants, how much do you know about what has gone on, how much documentation have you been allowed to look at, things like emails and things that you would not normally be able to privilege. That makes a big difference. But when I get to the end, and a lot of the clients don't want to have the written report, then I have to get assurances that I have the same exact information delivered to the audit committee. I can actually get a briefing a separate briefing from counsel, perhaps. Sometimes you actually wind up sitting in the original meeting, and then if I get a separate briefing from counsel, I would have to get representations from the audit committee to say what I just heard was exactly what they heard, minus the legal strategy part of the discussion. That would be, I'm interested in the investigation. Your legal positioning is something different, and sometimes they will leave that part of the discussion out and have the discussion about what the facts were, what happened, what are our conclusions.
Tim, you're pointing to the problem of the investigator telling the audit committee, boy, was there a lot of illegal activity,
Yeah.
and then going to the auditor in a separate meeting and saying, it wasn't so bad, nothing for you to really worry about. And you're saying, if there's not a written report, I need to be plugged into that dialogue between the audit committee and the lawyer.
I want to be plugged in the dialogue, but if I've been doing everything right all along, I have a pretty good sense what's going to be there in the end anyway. So I have a higher level of comfort. If I'm coming at the end of the process, how do I get the level of comfort in this process? It's much, much harder.
How do you, talking about going along in the process, as you're going along, if the lawyers don't seem to be asking the right questions, if the forensic accountants don't seem to have their heart in it, how does the auditor react to that? What does the auditor do?
Well, it depends. I mean, you can actually have discussions about the kinds of things they're asking without taking a direction of the investigation itself. It's a tough line to follow sometimes, but if there are questions you should have asked, we can have a discussion about that. Why was that not asked? Should it be asked? They can go back and ask it later. Or, remember I talked about those additional audit procedures. Under SAS 99, the fraud standard, should I bake in more discussions in those SAS 99 inquiries of the individuals that they've been speaking to make sure I'm asking the questions, that I understand what's going on? Should I be asking for the documentation they're looking at as part of my audit? What are the additional audit procedures do I need to do to augment my understanding of what takes place in that investigation?
The other point I'd like to make about reports is, I know remediation is our next topic, but I think there's a connection between remediation and this question of whether or not you get a report. And again, it goes to how clear the circumstances are. If the circumstances are clear and the remediation is clear, the auditor can understand a lot about the conclusions reached by the board as a result of the investigation from observing the remediation. So, I think sometimes, people get into a tussle over whether or not there's going to be a report before it's necessary, say at the very beginning where everybody's trying to anticipate what the outcome is going to be. Right. It's always possible to write a report if that becomes necessary. The only thing that argues against that, of course, is the fact that in many situations you're time pressured by reporting or filing deadlines, so it can become difficult. But you can, to some extent, you can wait and see whether or not a report is actually necessary.
And Steve, I'll tell you, you can imagine I've had many, many discussions with audit committees and auditors on the need for written report. When I've served as audit committee counsel and spoke to them about the pros and cons of a written report, the audit committee often comes out of that discussion deciding they want a written report for their own purposes. If they don't get their own written report, I remember one, you'll like this one, Cindy. I remember one where the company's trying to be real cautious. No written report, no written report. Okay, so they have a presentation to the board of directors, and what happens? The investigating lawyers put up a PowerPoint. So right away you've got a written record in the PowerPoint, and I look around the table, and there are a dozen directors, all of whom are taking notes. So then you've got and this isn't privileged, of course, because the auditor's in the room. So now you've got you don't have one written report. In substance, you've got 12 written reports because all the directors are taking notes. And sometimes you're better off with just one crisp, accurate, reliable statement of what happened. And then you don't have to argue about what the investigation actually uncovered. Sometimes often audit committees will find it serves their own interests in getting a written report.
Well, that brings us to our next step. So you've got the report, you have a crisp, clear understanding of what happened. Now what? You need to remediate. So what are those factors? What should we be looking at there from each of your perspectives? Let's start with you, Steve.
Well, I think from the perspective of the forensic accountant, a lot of the questions about remediation really fall into two buckets. One is the question of remediation of people who may not have behaved the right way, and that's often a very fact-intensive judgment about exactly what was their level of participation. And the second area is the question of internal controls and whether or not they need to be altered, improved, and so forth in order to prevent the activity in the future. And that question can expand even to the larger question of not the control procedures per se, but just the entire question of the operating culture and style of the corporation can sometimes be called into question. And that is something that's visible in some of the larger Foreign Corrupt Practices Act investigations, for example, where the sales culture or sales behavior of a company is called into question on sometimes a worldwide basis. So there, the remediation of that type of cultural problem is a really big issue and a big effort.
That's more of a pervasive risk rather than a specific risk to deal with. And sometimes those pervasive risks are a little bit harder to address, but certainly after you've looked at the investigation, measured the effects, considered misconduct, then you have to move on to, I like to move on then and start thinking about what counsel's recommendations are. Then I got to bring into bear something I said earlier, and that's my additional audit procedures and what they've shown me. Then start thinking about significant deficiencies, potential material weaknesses, and then think about this. It's a lot of people leave out this whole idea of pervasive risk. They know you might have a specific line item risk. I got to put another control in, but this may have really been driven by tone at the top issues, perceived pressures in the organization, different mindset to start thinking about pervasive risks in organizations. So not just the specific risks, the significant deficiency, material weakness, but also the pervasive risks.
Well, and that touches on a question that we've gotten, which is when in this process, if the remediation isn't effective to address these pervasive risks, when should the auditor resign?
Wow.
Excellent question. Steve, you handle it.
I'll be happy to handle that if you'd like. I think the auditor should resign if the investigation shows that management is not to be trusted and is unwilling to take the remedial actions that the auditor believes are required. This is where I think the rubber meets the road on the resignation question. Investigation is done, the results are in. The auditor is obligated by Section 10A to evaluate the adequacy of the remediation. If in the auditor's judgment, management and the board are unwilling to take adequate remediation, then the auditor has to think about resigning.
And let me just build in the law on that. That's actually pretty much what 10A says. It's a legal requirement. It goes back, remember the concept that we talked about at the beginning. This all comes under the umbrella of timely and appropriate remedial actions, and that's up to the judgment of the auditor. But if the auditor concludes, to Steve's point, that the audit committee and its investigators are not taking timely and appropriate remedial actions, you got 24 hours to go to the SEC, and the way the statute is written, resignation usually happens in that context, and the auditor is called upon to consider that.
Any part of this process could lead to that.
Absolutely.
Not just the remediation part of it. I haven't had a situation myself where there's been issues. Sometimes you'll understand what their proposed remediation is, and you may have a different idea of what you need to satisfy yourself that it's appropriate, particularly people who are in financial reporting positions or people that you're relying upon for financial statement representations. It depends on the roles. People, you may have a different opinion about these things. You can have discussions with them, but I have not had a situation where I got to it and they did a great investigation, everything I want to do, they write everybody and got down to the end and said, we're not going to fire anybody.
Right. But in actual practice, the whole structure around the 10A process and the modern corporate governance structure is designed to prevent ever having to get to this dramatic decision of whether the auditor needs to resign because the remediation is inadequate. And this is, again, back to setting things up properly at the beginning. Independent counsel to investigate, properly assisted by forensic accountants, auditors in their role looking over things. The board has to behave properly. They may need a special committee. They may need to go to a special committee of only independent directors to assess the situation, especially if you have major shareholders who are in significant management roles on the board. But all of these things are, in effect, safeguards to see that the whole problem doesn't blow up at the end in an auditor resignation and a report out to the Securities and Exchange Commission, because that just doesn't help anybody in the final analysis.
I'm sorry, a lot more proactive audit partners don't wait till they have an issue to start the discussion. When they undertake the audit for the year or when they first get retained, they'll start talking about 10A obligations. We have one of these issues. This is what we're going to have to do. You might as well know it.
Before you even suspect,
In fact,
at the
you
very
may never
beginning
have
of the
the issue.
engagement,
Yeah,
you have this conversation.
You can have the conversation. I know people who do that, the conversation right up front.
That's very good advice.
These are
one aspect of the remediation involves how the company deals with its employees. I mean, Tim, you earlier said, they do an investigation, they find lots of wrongdoing, and the company says, well, that's great, but we're not going to fire anybody. And that's a tough issue. When I think of the broad category of remediation, I think of four things. One is an adequate investigation. We've talked about that. Second is corrective disclosure. Often that'll mean a restatement if the problem was material. First, investigation. Second, corrective disclosure. Third, discipline of employees. Steve referred to that as remediation of employees. And then fourth, needed enhancements to internal control. Focusing on the third, that's one that tugs at the heartstrings a little bit. Now, if you've got, a situation where you've got a filthy, disgusting, horrible, defrauding, criminal, corrupt CEO, I don't feel so bad about that one. But what about where you're talking about people, mid-level people, junior people in the accounting department who were told by their superiors to do things that weren't right?
Well, I think on the people remediation or disciplinary process, I mean, that process has to include an understanding of what their role and responsibility actually was within the company. So it's not necessarily the case that the person who did the act, let's say of falsifying a financial record, is the person who's really responsible for the act. And I think in looking at how employees have been disciplined, it's important to understand that aspect of it. I think it's also important to understand that everybody thinks of discipline in terms of, well, let's fire the guy. But, there's many other steps to disciplining employees. You can put people on probation. You can change their job responsibilities. You can give them more oversight. You can demote them. You can change their bonus or dock their compensation in some way. You can take away stock options. You can take them out of the line of responsibility for financial reporting.
But Steve, let me ask the tough question, though. Thinking of it from and I agree with all of that, but what about the auditor? Suppose you've got a mid-level person who behaved dishonestly because of pressure, otherwise a really well-meaning person, and now how does the auditor react to that? Can the auditor take that person's representations?
I think it's going to depend on their knowledge of what they were doing, their culpability, and company policy, because a lot of times the CFO can direct a transaction. It may have seemed appropriate to somebody, it was an inappropriate transaction. Well, that makes a big difference. If they resorted to do a transaction didn't make sense, and company policy says, you don't understand something, you better call somebody. I think it all depends on a lot of different factors. But if it was obviously blatantly a fraud, you posted the annual journal entry, then that's pretty cut and dry. If you didn't understand it, but you should have said something because company policy says it, well, that's problematic, but that might not be termination. And then you have some that put the entry and didn't know one way or the other what the problem is.
I think, Mike, there's also a distinction to be made in this concept of how the auditor receives, quote, representations from a member of the client's business. Obviously, there's the very formal representations that come in the form of representation letters that the auditor is obligated to collect, and you probably want to have a different thought process around people who are signing those letters as compared to employees with whom the audit team is working and is discussing transactions with them. They're reliant upon them for the provision of files and other materials used in the course of the audit. Of course, you would have a concern if that person had been shown to lack integrity or credibility in the execution of their duties, but I would just suggest that there might be situations where it's inexcusable and the auditor will reach the conclusion the person either has to leave the department, have nothing to do with financial reporting, or be dismissed. But there might be other circumstances where the auditor could understand that the failing was a reasonable human failing, not born of any intent to deceive the auditors or engage in an illegal act, but was just succumbing to the pressure or dominance of those who are leading their department.
One other interesting aspect of terminations, in a few cases, even before the investigation got underway, management suspected a problem and terminated immediately. That's been problematic in a lot of situations, because if you terminate someone, you no longer have access to them for investigative purposes. So one of the things you may want to consider is some sort of administrative leave, so you have access to people. Sometimes they want to do the right thing, they're quick, boy, they're going to fire, but you can't ask them any questions anymore. They're gone. They're not going to talk to you if you've let them go. That happens once in a while.
Let's move on to our last topic, and then we'll go on to questions. But we've invoked the SEC's name several times during the conversation today, and then there's also the Department of Justice with respect to criminal actions. So can we talk a little bit about that interplay, those expectations, and then what it is that the auditors need to do at presentations to the SEC?
One of the interesting things, Cindy, is the multiple layers of an investigative structure that get put in place. You've got the law firm that's doing the investigation and the forensic accountants doing the investigation. You've got the audit committee overseeing that process. You've got the auditor overseeing all of it, and now we're talking about one or two additional layers of oversight, the SEC and the Department of Justice. A few years ago, you almost couldn't get the Department of Justice to take on an accounting case. Now the different offices fight over jurisdiction of them. How time has changed. So that often means that you will, if you've got a big accounting irregularity issue, you should, the SEC is going to get involved. The Department of Justice may also get involved. And of course that complicates things enormously, because now you may have people taking the fifth. Now when you interview the CFO, Steve Skalak sits down and interviews the CFO, and the CFO says, I ain't telling you a thing, I'm taking the fifth, because I know you're just going to turn it over to the SEC and the Department of Justice, and they're going to use it to put me in prison, and last night I watched guys getting pulled out in handcuffs, so I'm not doing that. Of course, that makes the job a little more difficult. How does the auditor deal with that? Well, you play the hand you've been dealt, and if the CFO isn't singing like a canary, then you say to Steve Skalak, Steve, we need your team to do extra digging, and we just have to get all the more information. A critical aspect of the government, whether it be the SEC, the Department of Justice, the PCAOB, let's add another second guesser, a critical thing is that the auditor really likes to see cooperation between the audit client, between the company and the government. And if there is stress between the company and the government, that can be a little bit of a warning sign, because remember, an angry government flings out at everybody. So generally, cooperation between the SEC and the company is a good thing.
Now, I assume there's going to be a presentation before the SEC of the findings. Does the auditor participate in that?
Sometimes, sometimes not. I think one of the earlier questions was whether they should participate. I don't know, unless you do, of a requirement that the auditor be at the presentation, but obviously if you could be at the presentation, that's better than not being at the presentation. But I don't know of a requirement to be there. But I've seen situations both ways. And I've actually done investigations, third-party investigator, where the auditor was at the presentation.
Yeah, I mean, that's consistent with my experience. The practice is all over the map.
Of course, he was asked some very difficult questions at the time by the SEC.
Well, actually, Tim, that's really a good point. I mean, keep in mind that the SEC is playing two roles here.
Yeah.
One is finding out what happened, and the other is second-guessing whether the auditor should have caught the mess earlier. And if the auditor has somebody going to Washington and sitting in the SEC meeting, you could almost hear the SEC guys saying, thank you very much, very interesting report on the fraud. Now let me turn to you, Mr. Auditor, and let's talk about whether you conform to generally accepted auditing
What were you
standards.
thinking?
Yeah, what were you thinking?
But Tim, if you're the forensic specialist for the audit firm, presumably you would be sitting in on the SEC presentation, or maybe not.
Maybe not necessarily.
Not necessarily?
Remember, it's the engagement partners audit. So there's a lot of drivers who would be there. You could be there with someone like that, but I would think it'd be probably the engagement partner would make the most sense. But again,
would open themselves up to.
one situation when I was in a thing like that, I do remember the audit partner from another firm being asked some difficult questions who really wanted to be there, and I thought to myself, you probably wish you hadn't come.
Well, at this point, I want to stop and just, we'll do our CPE code, and then we'll go into the question and answer period. So for those of you who are seeking CPE credit, I'm going to now read you the code. You need to write it down, keep it with your materials, and then later on in the webcast, I'll tell you how to use this information to get your CPE credit. So the code is ALL 0627. Again, that's ALL 0627. And I will note that our three panelists are writing down that code because I'm guessing they're looking for CPE credit too. Those
Actually, I get no credit for this whatsoever.
Grateful to the opportunity to get some CPE.
So we do have a few questions that I would like to go ahead and ask. We've had a few questions around the privilege issue, and as I read these questions out and we answer them, I do encourage all of our listeners and viewers, if you have questions, please type them in, because we have built in some time for questions, and you've got the three experts here, so you really should avail yourselves of their expertise. But some of the questions that we've gotten, again, are around privilege, and is there any way to protect the privilege through confidentiality agreements between the auditor and the legal counsel, or between the forensic specialist and management?
Just the forensic specialist piece of that is easy, so maybe I can go first and just say, for the forensic accountant, their materials will be part of counsel's materials and subject to whatever rule counsel's materials end up being subject to. As the forensic specialist, we always act in a manner that preserves every privilege owner's right to assert the privilege. So we're careful not to destroy anyone's privilege, but in the end, we're subject to whatever rule governs the investigating counsel's work.
And let me answer the question, and I can do it with two letters. No. There is not a way to structure it so that the privilege is protected. And in fact, I'll go one step further. It is dangerous for the auditor even to walk into that. Because what happens is, once the auditor, now this is my view, and I'll accept that others may have different reactions. But my own view is, once the auditor starts walking in that direction, then it becomes, well, let's talk about what information the auditor will get and what information the auditor will not get. And let's give the auditor a hypothetical, and if I count to 10 and I get to 5, that means it's true, but if I only get to 1, and I only get to 7, that means it's not true, and I'll nod and move my coffee cup. And don't go there. Don't go there. And some of that has been judicially tested and found it doesn't work. You really need to have transparency between the auditor and the investigative results. And it's going to be up to a judge. Now, a judge may, in court, down the road, conclude that there was not loss of privilege or a related doctrine work product, although I think most lawyers would tell you that's unlikely, that the judge would so conclude.
I think that's less likely, yeah. But the cases I've read, the privilege wasn't upheld. But
the privilege is, the general rule, I can tell you, the conventional wisdom among lawyers is, if the company gives it to its auditor, it's lost the privilege.
But a few times it has been upheld.
Sometimes.
Well, likewise, and this goes to a question that we have as well, too, if the company gives it to the SEC, does that also sometimes blow the privilege?
You know, Cindy, great question, because the SEC has actually walked a little down this road of trying to structure things to protect the confidentiality, and they have historically been willing, under the right circumstances, to actually sign an agreement saying, as far as we're concerned, it's still confidential and privileged. Generally, the courts have not upheld that.
And of course, I think, Tim, most audit teams would argue that if the client is sharing information with the commission, it would be unfair to expect the auditors to conclude the audit without having had the sight of the same materials.
Yeah, absolutely.
Yeah.
Well, and that actually touches on another question that we've just gotten, which is we talked about earlier whether or not the audit firm or the forensic auditor should be present during the interviews. If the auditor is not present during the interviews, is there a re-interview process? You mentioned, Tim, that you could talk to counsel, you could interview counsel, you could satisfy yourself that way.
There's no prohibition for me to go speak to the same individual in the context of Access 99. And sometimes you'll have conversations with somebody. But usually, if you've got a good working relationship with counsel, you come away from discussions with counsel or oral briefings on it feeling pretty good about what took place, the kinds of questions they asked. They were rigorous enough. They dug deep enough into these things, particularly with respect to the probing questions. It depends on the relationship with counsel and with the forensic accountants you're working with.
Let me offer an audit committee perspective on that, or audit committee lawyer perspective on that. When I'm doing the investigation, when I'm the guy doing the interviews, I sometimes like the auditor to be there. I want Tim to be there, first because I want to be transparent, second because I want him to trust the investigation, third because he may have useful reactions that I will want to take into consideration. But there's a downside. Of course, yet again, you're blowing the privilege to smithereens. But I'm past that. One downside is it may be a chill on the conversation, because one of the subjects may be, did you lie to the auditor? And if the auditor's sitting there, that can make candor more awkward for the poor mid-level accountant who needs to honestly say, yes, I did lie to the auditor. So there's so much of this is balancing.
Mike, from just a forensic perspective, I think that interviewing is enough of an art as opposed to a science that it doesn't bear the burden of extra participants very well. And if you're truly engaged in an information-seeking interview on a topic that is sensitive, that is enough of a difficult circumstance in and of itself. But I think the investigative team really ought to have the full sort of freedom to conduct the interview in the manner they think is appropriate without a lot of extra observers.
Steve, that's such a good point, because the general rule is the quality of the interview goes down with the more people in the room. Right. The best interview is me by myself sitting with the CFO and just asking him questions and giving him an opportunity to unburden himself. And the minute you start loading people in, I had one interview, I remember it was a full conference room, like 23 people sitting around trying to get a candid conversation.
It's a focus group.
Yeah, right. I mean, you just can't get the thing going. That's it, Tim, you're exactly right.
So given this, that unfettered one-on-one or small group, is it appropriate for the auditor to ask counsel or the forensic auditor ask specific questions?
Well, from my perspective as, forensic accountant, we're always open to knowing what the auditor's concerns are. We like to know what the auditor's concerns are. So I find that generally very helpful in the formulation of the interview plan, both with respect to the questions as well as who we will speak to. So I never object to that.
I mean, one useful way for an audit committee to look at it is the auditor is the main audience for your investigation. I mean, the purpose, you don't do these for fun. One of the main purposes is you want the auditor to stand behind its audit report, or if necessary, if there's going to be a restatement, to issue a new audit report. And the auditor is not going to do that unless the auditor is satisfied. So the auditors, the way I try to explain it to audit committees is, your job is to make the auditor happy. If the auditor says he or she wants a cup of coffee, make sure it's hot.
Which comes to another question. Our questions are very good at prompting us to move on to another topic. This is all presuming that there's a good relationship between the internal audit function, the audit firm, the forensic auditor, the counsel, and the audit committee. What if the special counsel or the forensic auditor or accountant have been fired or terminated during the process because the audit committee has lost faith, lost confidence? What then does the audit firm do? What do you, as the forensic specialist to the audit firm, Tim, what do you do in that case?
Look at the facts and circumstances, because were they fired because they weren't doing a sufficient job, or were they fired because they were doing too well? I'm not sure what it depends on how I understood that issue and whether or not I could have the conversations with those that were terminated to help understand this and have a conversation with the firm. I think that's a hugely difficult question. Fortunately, I've never had to have the problem, but it depends on why they were terminated. And usually you can see if they weren't doing a good job. Actually, I've had a couple where they've come with different law firms with different levels of expertise, because you could see that this wasn't their issue. It may have been OFAC. It turned to be an OFAC issue, an RCPA, and the law firm said, well, this is really not our area. Another one has come in, and they had more expertise in it. You see more of that stuff, I think.
Well, go ahead, Steve.
I was just going to say, I think it goes back to everybody staying in role. And, if the investigating counsel and their forensic accountants have been fired, the auditor merely asks the question back to the client, how will you now carry out your responsibilities under Section 10A to adequately investigate this matter? Because it's still the client's responsibility to conduct an adequate investigation. The auditor's responsibility is to resign if the client fails to behave properly.
But sometimes you need to get rid of people to change the culture so that the truth comes out. I mean, if you've got a corrupt CEO and a corrupt CFO, and I'm as investigator, I'm saying to a person several layers down, what happened here, they know that I'm going to leave, and that CEO and CFO are still going to be there. And therefore, to sort of deal with that, picking up on your concept of administrative leave, when you have the evidence, sometimes the CEO and the CFO have to go at an early stage.
Yeah.
It's a tough
Very,
area.
very effective way to loosen tongues.
Is it appropriate to hire for the independent investigation your normal corporate counsel? Or should you go? See, that's another issue.
That goes to independence.
Yeah,
that goes to independence.
That's an interesting thing. And because sometimes you will see the like normal corporate counsel looking into the issue and having to be replaced by other counsel and they understand what the.
Sometimes that happens because you get a whistleblower on Friday, and you may have to put out a press release on Monday, and you don't have time to bring in independent counsel, so you turn to your outside counsel.
It's hard to bring in the right counsel. You got to go through the interview process, understand who they are, vet them. You already know these counsel, and they're probably qualified. They do the preliminary work for you, but once it's discovered, who are you going to go to next?
That's right. The preliminary phase. I mean, earlier we talked about the preliminary phase. You do with the troops you got on the ground. However, then once you get past that, then you put in your more permanent structure for investigation.
We have time for one more question, and then we'll wrap up. But the question is, what happens when a key person involved in the investigation refuses to be interviewed?
It is my own view that an employee at any level, from the CEO to the guy at the loading dock, has a responsibility to truthfully answer the questions of his or her employer. And I think that is probably a widely shared view. And if an employee refuses to be interviewed, then you got to think about termination.
But any other way to get the information that you want from that particular person?
No, any investigation. I'm sorry, you were asking.
I was asking both of you, or either of you.
Because usually you go through a process of triangulation anyway. I don't just rely on the interview to understand something. I'm looking at the electronic documentation. I'm looking at other materials. I'm looking at third-party information to triangulate and understand. Because I have to corroborate. If I was interviewing Mike, he was interviewing me, he's got to corroborate what I'm saying to him. I'd have to take those other procedures as well to corroborate. And I would hesitate to take a process like that, because you can't make someone speak to you.
Nothing really to add to that other than in the electronic day and age we live in, it's very rare that there are no footprints or substitutes for a person's recollection or memory about particular events. But nevertheless, I fundamentally agree with Mike. If an employee refuses to be interviewed in the course of their employment, I think probably the employer has a pretty good basis for terminating their employment.
Well, we've had a fascinating hour and a half here. We're very pleased to have this great set of panelists. We've got a number of questions that we haven't been able to get to. So how I would like to wrap up is to go around the table, and we'll start with you, Steve. What are your key takeaways? If you leave, if our viewers leave here with nothing else, what's the one thing you would like them to take away with them?
Well, presuming our viewers are primarily auditors, I would say the one takeaway for them ought to be to make sure the right team is involved, because back to Mike's point about the auditors being significant consumers, as it were, of the investigation, the auditor doesn't want to be sold a bill of goods. And that means having the right team involved to conduct the investigation. And I would even go so far as to suggest, especially if you're at a smaller firm, that may mean making sure that your forensic accountants have walked in your shoes and are themselves auditors of financial statements.
Excellent. Tim, your key takeaway?
I think things I discussed before, being involved up front as far as for the auditor, move lockstep with the investigation, and probably most importantly, maintain a heightened level of professional skepticism in these situations.
For me, it boils down to two words from an auditor perspective: independence and transparency. Make sure the investigation is independent, and you need to have transparent access to the results of that investigation. Independence and transparency.
Well, excellent. Gentlemen, I thank you so much. Steve, Tim, Mike, you've been fantastic. Great information, great advice, great counsel. So I thank you again for taking time. And to all of our viewers, I thank you for joining us today. I'm Cindy Fernelli from the Center for Audit Quality, and I wish you all a good afternoon and a good weekend. Thank you.